Excuse me, I have to sneeze after that. But no, this is a really, really weird situation. They had just started up. We didn't expect them to go to a break so early. Not sure why that was happening. Perhaps there has to be a discussion between the attorneys and the judge in regards to that. But that was the first witness, a forensic pathologist called by the defense right as she was getting into these photos of the back of Laquan McDonald's head. We're confused on our end about where they're going to go with this witness. We thought perhaps they would go talk about PCP. Perhaps they would talk about what was in his system. But to get into the actual forensics is an interesting scenario. Now, let's bring in, we have with us, I'm so happy joining us, jury consultant Alan Tuerkheimer. Alan, welcome here to Law&Crime.
Good to be here. Nice to see you.
So I'm not sure why they went to a recess so quick, but the jury is sitting there and they were looking at these autopsy photos of the defendant, now, of the victim, and we saw a little bit of them last week. How does a jury made up of regular human beings able to sit there and look at these graphic photos?
It's not an easy thing, and I think they're wondering what you're wondering, what I'm wondering. They understand that he was shot 16 times and killed, so what is the point? For some jurors, it's just going to be too graphic. Some are probably looking the other way. They understand that there's some importance, at least the attorneys think so, but they're probably scratching their heads wondering, why do I need to see this? I already know the end result, but what is the purpose?
I got to say, sitting on a jury isn't easy, but let alone in this case. This case is getting a lot of media attention. There are a lot of strong opinions on both sides. What do you think it's like to be sitting in that jury on such a monumental trial?
It's a tough task, and every time they go to the courthouse, they're the protesters or security. Everything is beefed up and ramped up. I think at some point they start to get used to it. You know that the nation is watching. This is significant, and it's difficult to do this. Any trial is really difficult, let alone this one that has such high scrutiny. So many people paying attention to it. So it's not an easy task. I think they're cut out for it. They're going to do their best. It's not easy to expect them to do what they're asked to do.
Do you think, though, that this amount of media pressure, I know they're trying to be excluded from it, do you think it could potentially influence their decision?
I think that the judge is doing a nice job of it. They're certainly aware of it. But I think ultimately they're going to get used to focusing on the evidence, listening to the witnesses, and doing what they're supposed to do. So I think that it's going to be decided based on how it needs to be decided. They certainly are aware of the media scrutiny.
And when they were being questioned about being jurors, you hope that they were going to be impartial and take in both the prosecution's case and the defense's case, which began today. And the question also is, will the defense ultimately call the defendant to the stand? We heard John Spilborn yesterday talk a little, earlier today talk a little bit about it and how it's so important to have him take the stand. And what will the jury response be if he does? Well, we're going to have to talk to Alan a little bit more about it when we get back from our break. So let's take a quick break on our end, and when we come back, there's a lot more to discuss here on Law&Crime. So stay tuned. We'll be right back. All right, apologies, ladies and gentlemen. These are very graphic photos that you were seeing of the victim, and now we are getting the defense's perspective on it. Let's bring back in Alan Tuerkheimer. Alan, when you're listening to this and you're thinking about what the jury is going through, when they hear the expert testimony of the prosecution's witnesses and then hear the defense, how do they balance the two different experts when they have two different opinions?
That's an excellent question. They assess credibility. They listen carefully. They see how the demeanor changes from direct to cross of the witnesses, and then they make a determination. Do they decide whether or not the witness is likable? Are they credible? Do they give new information that they can take with them? So it's really an individual assessment, and a lot, I think, as you're alluding to, sometimes it just cancels out. One says one thing, the other says the other, and then jurors have to either look elsewhere or decide which side's witness are they going to give the tiebreaker to.
And it's important to hear those credentials at the beginning of their testimony.
Right. They want to know not only if how they're connected to the case or how they were brought in, but what their experience is like, where they went to school, and where they did their training, because that also, as you said, factors into how much expert ability they feel like they have and what they're going to do with that in the deliberation.
Right. All right. Well, we have to take a quick break. A lot more to discuss right after this. Stay tuned. We're covering the Jason Van Dyke trial. Okay, so now we're trying to understand exactly how and when Laquan McDonald died. Back here with jury consultant Alan Tuerkheimer. Alan, make this sense for me, for common sense. You're sitting on the jury. Didn't we just hear all about his injuries when the prosecution put on the case? What is the defense trying to do here?
Yes, it seems redundant. I think they're just trying to show to the jury that it wasn't all 16 of the shots that killed Laquan McDonald. Maybe it was just 1 or 2 or 3 of them, trying to minimize the notion that all 16 shots killed him. I'm not sure why they're doing it. If I'm the defense, I want to focus on Laquan McDonald just before the shooting and what might have happened afterwards. So I don't think this is really helpful. I think jurors are probably scratching their heads. It's not very streamlined at this point. So it's a little unclear exactly what they're trying to do and how effective it is.
I would guess that they're trying to say the idea of firing 16 bullets into this live individual and killing him was maybe just too graphic, but we'll have to see. We'll take a quick break. We'll be right back. Stay tuned. Okay, so you're already starting to hear the differences between what the defense is saying and what the prosecution was saying with their medical examiner about what bullets hit Laquan McDonald and how many. This is a really important aspect. Want to bring back on Alan Tuerkheimer, jury consultant. Alan, we talked about it earlier, the idea of maybe the defense bringing the defendant on the stand, bringing Jason Van Dyke on. If that happens, what's the jury going to think of it, and what will they be looking out for?
Well, it's certainly a gamble because he's going to open up himself to cross-examination, but I think they need to do it in this case because the defense is that he feared for his own life or someone else's life, that he thought that the Laquan McDonald could inflict some danger, serious danger, great bodily harm, and only Officer Van Dyke can testify and give a clear picture of what was going through his head, what he was thinking, what he saw at the time he fired 16 bullets into Laquan McDonald. So I think if that happens, jurors are going to get what they wish for if he testifies. And if they don't, they're going to be left wondering what he would have said.
I wonder how much of his testimony would be a make or break for some of those jurors. We'll have to see. Alan, stand by. Here's what we're going to do. We're going to take a quick break. I will be signing off. Bob Bianchi will be signing in. And he's also going to talk to you about a major case that we're covering here on the network. We're waiting for the Quentin Tellis trial. This is what I'm talking about, the Jessica Chambers retrial. You're not going to want to miss this. We have a special message from our very own Aaron Keller. Let's play that for you right now.
Okay, we are at a critical point in this case. A defense forensic expert. The chat room in the Law&Crime Network is on fire. We got some great questions from Diana 421 and Wrigley T and many other people. And I got to ask, Alan, you're still with us, and you're a jury consultant. And so there's a sensibility in that chat room, and I look at the chat room as a jury pool. These are people that are listening to this testimony unraveling. Like, why is the defense expert bringing it all up again about all of these shots? And Wrigley T actually had a pretty interesting comment that maybe if you prove he was dead within the first 2 or 3 rounds, that all the other aggravated assault counts would have to be dropped. What are your thoughts about how this impacts the jury?
Right, I think that's the angle. They're just trying to minimize the impact of 16 shots because that's what the prosecution's been saying. The jurors have seen the video several times. So basically trying to get them to focus on these 1 or 2 shots that actually killed Laquan McDonald. Now, I think you're right. I think it goes to the 16 counts that they're trying to get favorable interpretation on. But they keep showing the wounds, and I just don't think that's that helpful to the defense. I don't think jurors are going to attach that much significance to it. The defense wants to have the jury focus on what happened right before the 16 shots and what may have happened had Laquan McDonald not been killed. So It could go both ways. I don't think it's going to make or break what happens with the jury, but it's very interesting indeed. And like you say, the chat room is a good place to go.
Alan, as a prosecutor, we always want to get as much those autopsy photos out as much as a defense. You typically want to limit them just in 15 seconds or less. Tell me, what impact is it? Maybe they get desensitized to it.
Right. Well, that's what I was going to say. I think the more jurors see it, the less of an impact it makes. They see it over and over and over. And if I was advising the prosecution, I would say show it once, that's it. The jurors get it, and then move on. So that also could be a tactic by the defense.
Okay, excellent. Listen, guys, you're at the Law&Crime Network. Let me tell you, we are humming. We got people in the back room. We got all sorts of news that's breaking. We're going to come back with more analysis shortly. Stay tuned. Okay, welcome back. So there you see the defense forensic pathologist. You got to love our chatters in the Law and Crime Network. Get on there and listen to it. They're our jury. They guide us. Alan, sure as we were talking about, Wrigley T brought up the issue that they're trying to mitigate the number of shots in terms of the aggravated assault charges. And that is clearly based on the questioning that the defense lawyer was asking was where they were going. That was one part of it. Do you think it was effective?
I think they're doing a pretty good job. The key takeaway for the jurors is probably that this is a thorough witness. I think compared to the prosecution, it's more detailed, and I think it was a deeper analysis. So I do think that some of it's going to get through. I'm not sure overall how it's going to apply to the murder charge and this overarching story that jurors have of what exactly happened. But I think they have to do this. I think maybe it could be a little more streamlined. But I think they're being pretty effective about how they're going about it. They're pretty meticulous, and I think the jurors are finally getting what the purpose is.
Right, and she also testified, which is consistent, and a corollary here is that multiple gunshot wounds is in fact a common phraseology in pathology world, and that most of them were through and through wounds of limbs, and that this expert has never seen one in her official capacity that through and through wounds to the limbs actually caused death. I thought that was an effective question.
Yeah, I do too. And, you know, a lot of this witnesses have to think about how a jury's going to receive it. And it's always an opportunity to teach. And so this is something the jurors wouldn't know about. And so when the witness gets up there, you want to teach the jury. You don't want to be condescending or too elementary. But I think it was a good opportunity to explain this. And I think it was an effective way of getting that notion across to the jury. I think they appreciate it.
Okay, guys, you are in the Jason Van Dyke trial. This is a police officer, former officer, on trial for murder. It's a fascinating case, another great poll by the Law and Crime Network because it brings in so much, including self-defense, use of force, murder, manslaughter, and other things. We're going to go to a break. We'll be back on the other end. Okay, welcome back to the Law and Crime Network. Defense experts testifying right now. We've had Alan Tuerkheimer with us, a jury consultant. Alan, you've given some great analysis. I'd love to have hours with you, but I know you got to run. But we'll catch you back the next time. Thank you so much.
Thanks. Good to be here.
Okay, we'll catch you soon. Let's get back into court and listen to some more of this fascinating defense forensic testimony.